5 seconds to go. Start. Canara Bank is in appeal by special leave aggrieved by the judgment and order dated 4th November 2019 of a division bench of the High Court of Kerala at Ernakulam, dismissing an intra-court appeal that it had carried from the judgment and order dated 9th June 2016 of a single bench allowing the writ petition of Ajithkumar G.K. The facts leading to this appeal are not disputed. However, a brief resume is considered necessary to decide the appeal. Father of the respondent passed away on 20th December 2001 while in service of the appellant. He had 4 months service left prior to superannuation. A scheme for appointment on compassionate ground formulated by the appellant and contained in circular number 154 of 93 dated 8th May 1993 was in force when such death occurred. Within a month of his father's death, the respondent applied on 15th January 2002 seeking appointment on compassionate ground. On 30th October 2002, the respondent's plea was spurned by the Deputy General Manager of the appellant. The reason assigned were twofold. Mother of the respondent is in receipt of family pension of rupees 4,367.92 paise, and hence the financial position of the family does not warrant an appointment on compassionate ground, and the respondent was overaged for the post of probationer peer. Incidentally, the respondent was in excess of 26 years of age, and in terms of the scheme of 1993, the maximum age limit for appointment on a clerical post as well as in the sub-staff category was 26 years. The scheme, however, provided for relaxation of the upper age limit up to a maximum limit of 5 years. For members of the scheduled caste community, ex-servicemen, and physically disabled candidates, special relaxation was also provided. The respondent, though overaged by a few months, was not considered by the appellant for such relaxation. Nevertheless, the respondent on 7th January 2003 prayed for reconsideration of his prayer. The Assistant General Manager of the appellant conveyed to the respondent on 20th January 2003 that the financial position of the family of the deceased employee had previously been examined in depth by the competent authority, and there being no fresh ground for reconsideration, he regretted inability to consider the prayer. This was followed by a request dated 4th February 2003 of the respondent's mother seeking reconsideration of the application submitted by the respondent for protecting the poor family of the deceased employee who had served the appellant for more than 24 years. By an order dated 18th February 2003, the divisional manager of the appellant once again expressed inability to reconsider the application of the respondent's mother. The respondent, finding no other option, invoked the writ jurisdiction of the High Court of Kerala by presenting a petition under Article 226 of the Constitution. During the pendency of the aforesaid writ petition, the appellant issued Circular number 35 of 2005 dated 14 February 2005 introducing the scheme for payment of lump sum ex gratia amount in lieu of employment on compassionate grounds. The said scheme laid down provisions for coverage of family members of deceased employees who would be entitled to lump sum ex gratia payment. Most importantly, the circular dated 14 February 2005 discontinued the policy of compassionate appointment under the scheme of 1993. As is the case with high courts all over the country having immense burden of work but number of judges fewer than the sanctioned strength and for reasons beyond its control, it took the High Court more than a decade to decide the writ petition. Vide a judgment and order dated 16th June 2015, the writ petition stood allowed. The order passed by the Deputy General Manager dated 30th October 2002, refusing the respondent appointment on compassionate ground, was held by the High Court to be not at all in accordance with the scheme of 1993 launched by the appellant. Further, that while reconsidering the prayer of the respondent and his mother, the appellant did not advert properly to the laudable object of the scheme, especially its power to relax the age, as provided under paragraph 5.1 thereof, also that the orders impugned were liable to be quashed. Consequently, the appellant was directed to reconsider the issues raised by the respondent, taking into account the scheme of 1993 as well as the principles laid down in the decisions of this court in Canara Bank versus M. Mahesh Kumar and State Bank of India versus Somveer Singh, as well as any other relevant decision that is pointed out by the respondent. Accordingly, upon setting aside of the orders impugned, the appellant was directed to take a decision in the matter as directed within 45 days. In furtherance of the aforesaid judgment and order, the Managing Director and Chief Executive Officer of the appellant re-examined the claim of the respondent for compassionate appointment and once again declined favorable consideration of the claim. Relevant portions from the order dated 8 September 2015 passed by the MD and CEO read as follows. In the particular case of Shri Ajithkumar G.K, the following facts are undisputed. The ex-employee died with a remaining service of just over 4 months only, and the dependent family was eligible for full terminal benefits gross rupees 3.23 lakhs and net rupees 3.09 lakhs after recovery of outstanding liabilities and a family pension of rupees 4637 and 92 paise during 2002. He had then left behind his spouse, one unmarried son. The three daughters were married and settled. The son was aged 26 years and 8 months as on the date of application. The family of the deceased was drawing pension under the Canara Bank pension regulations. The primary and the most basic issue to be examined, therefore, is whether the dependent of the deceased employee was facing any immediate financial difficulties or penury on account of the sudden death of the employee. In the present case, there were no minor dependent children or unmarried daughter in the family for whom future financial assistance was required. The three daughters of the deceased employee were already married and settled at the time of his demise. The other deponents are his spouse and his son, Shri Ajit Kumar, who was then aged 26 years and 8 months. The family was residing in their own house. The last drawn net salary of Sri Vishi Gopala Krishna Pillai as on 2001 was rupees 9772, and had he survived for another 4 months, he would have otherwise supported his family with the pension he would have received from the bank in normal course, approximately rupees 6398 only. After the demise of the employee, his spouse Srimati Omana Amma was sanctioned with a family pension of rupees 4637.92 then, and which is presently rupees 5825 per month. that apart net terminal benefits to the extent of rupees 3.09 lakhs after closure of liability of rupees 13,942 as on 2002, which were available to dependents. Stop.